If you can move the order there.
Yes, please.
It's in our notice of motion for admission as an amicus. We ask for prayers 1, 2, and 3. Those involved admitting the UXA as the amicus curiae, admitting the affidavit filed on behalf of UXA, and granting UXA leave to present oral arguments that we have.
Yes, thank you. Mr. Goodman, you don't object?
We don't, my lady. My lady, whilst I'm on my feet though, could I raise a point of housekeeping? I see that there is a second application for amicus, for intervention as amicus. It's that of the Women's Cultural Group. They...
Might be on my case lines. I don't have a full set case. Sorry.
I'm afraid I don't have a hard copy of it, and they don't have appearance here. They don't seem to be.
Let me just see if they're on case lines. Yes, okay, I see there's a Women's Cultural Group that also wants to be admitted. Is there any objections further?
I haven't, we've indicated that if they came to court and applied, we wouldn't have an objection. But there's nobody here
Is there no one
for
here?
that. No. And I haven't actually studied what they want to say, but we've indicated to them in correspondence that we don't consent, but if they want to come to court, they can make it. That's my instruction.
Well, I mean, Ms. Goodman, if they're not moving their own application, what's the purpose of admitting them?
My lady, we are entirely agnostic. I merely raise it for I merely raise it for housekeeping purposes.
All right. Well, is there anyone here for the Women's Cultural Group? Well, then the application is not moved. All right. Yes, in the application by the United Ulama Council of South Africa for admission as amicus curiae, in this application on case number 21401 of 2020, prints 1, 2, and 3 are granted by the there is an issue of urgency.
Yes, madam. Perhaps if you want me to address you first on that.
No, I think let me hear the response. Yes.
My lady, I believe the court has our heads of argument on it. We've dealt with the matter very briefly. As your ladyship knows, this is a constitutional challenge brought by the applicants to the regulations issued under the Disaster Management Act. And it concerns in particular the provisions that enact the national lockdown that confines all of us, including the applicants, to our homes and requires us to leave only to procure essential goods and services. The applicants challenge those regulations on the basis of various constitutional rights, most preeminently their right to freedom of religion. And my lady, the state admits very readily that those are issues of public importance. We accept that they warrant urgent attention and that they warrant a hearing during the course of the lockdown. But my lady, we submit that because of the public importance in the matter, and because of the interest in these proceedings, not just to religious adherents, but to everyone, all of us who are under the confines of lockdown, we submit that the case also warrants a proper and full ventilation. And we submit with respect that that has been frustrated by the applicant's conduct of the case. If I could take your ladyship very briefly to the heads of argument, we've produced a short chronology in paragraph 6 thereof. And I must apologize, my lady, our heads of arguments don't include case line or pagination references because we only got pagination papers very late.
I don't. So, I have it. Paragraph 6.
My lady, I have a hard copy if that would be more convenient for your ladyship.
If I get stuck with it.
Thank you. So, your ladyship will see from paragraph 6 that the engagements between my clients, the state, on the one hand, and the applicants on the other, began on the 4th of April. That's more than 3 weeks ago, and 10 days after the lockdown commenced. And at that stage, the applicants wrote to the President asking for an easing of the lockdown regulations in order that they be allowed to attend mosque to pray in congregation. And the President's response was sent on the 9th of April. And it explained in detail, it's MM10. Thank you very much. The President explained in detail why in the government submission an exemption or an accommodation wasn't possible. And your ladyship has obviously read that letter and has seen that it was a substantive response. It was measured, it explained the government's thinking in some measure of detail.
Well, there's two means to encapsulate the sentiments of the majority of this particular religious population worldwide.
Indeed.
My lady, and specifically South Africa.
My lady, that is one aspect of it, but it also explains we would submit why an accommodation can't be easily made for one religion or for religious rights as opposed to other kinds of rights. So that response was sent on the 9th of April. The next step in the timeline was that the applicants prepared and sent draft papers to the State Attorney on the 12th of April. But they only served and instituted these proceedings formally 2 days later on the 14th of April. Correct. Gave us half a day to file notice of intention to oppose, gave us 2 days to file answering papers. Now, my lady, I need hardly remind the court that we are in exceptional times. 2 days for an answering affidavit for a case of constitutional magnitude is short in any circumstances, but it is extremely short in circumstances where government is tied up with pressing matters of state. And as we explained to the applicants in the correspondence that ensued, with daily meetings related to National Joint Committee, to cabinet meetings, etc. So the time period we submit was particularly unreasonable in the circumstances in which we find ourselves given the government's pressing obligations. Nevertheless, my lady, my clients filed their answering affidavit by Friday. I believe that there may have been a delay in that being transmitted through to the applicants. I think that they only got it on Saturday morning. They filed their supplementary founding affidavit on Friday afternoon, and we responded to that with a supplementary answering affidavit on Saturday. So the state has worked extremely quickly under very difficult circumstances in order to ensure that this matter came to court timelessly. But with respect, my lady, we have not received the same kind of courtesy from the respondents. They have taken more than 3 days they have taken 3 full days to file replying papers. We received an unsigned version of the replying affidavit after 5 yesterday afternoon, and we received a signed version of the replying affidavit at around 10. We were invited to the case lines meeting this morning, and only because the state attorney liaised directly with the court, and we got heads of argument a very short time ago after these proceedings have been set down. So, my lady, we submit with respect that the applicants have pursued this at a rather leisurely pace in the circumstances, and on time periods of their own choosing, while seeking to hold the state to extremely curtailed time periods. And, my lady, the consequence of that is to compel the state, but also this court, to deal with an important matter, a complex matter, on very short time periods, in circumstances where our ability properly to prepare and to prepare full and fully referenced heads of argument has been prejudiced.
And we are a week away from lockdown being ended.
We are currently a week away from lockdown being ended. I mean, I don't think that any of us know where
nobody's got
this
crystal
is.
ball this weekend, but at this stage, the lockdown goes and it's lifted from the 1st of May, which is next week, Friday.
Yes. My lady, it is the case, though, that in the intervening period, Ramadan will begin. And that is the basis on which the applicants pin their case for urgency. I understand that Ramadan is due to begin on Friday or Saturday, but it is not clear from the founding papers whether there are additional prayer obligations or obligations to attend a mass during that period. And so and my lady, I must say here that the applicants accuse the state of being insensitive to the pressing urgency of this matter. They say that if we were sensitive to their religious rights, we would consent to this matter proceeding. It is exactly the opposite, my lady. It is because the state takes this very seriously, and because it has wide ramifications for the lockdown more generally, that it says it must be done in a proper, orderly manner, and on a timetable that facilitates the proper hearing of it. So, my lady, Our submission is that the matter should be struck from the roll in order that it can be dealt with on proper time periods. I reiterate that we don't say it must wait until after lockdown. We accept that it is urgent enough to be heard during lockdown, but on a timetable that facilitates proper preparation.
But then we've got 1 week. What's the point?
My lady, the point is that the matter requires substantive argument. It is a matter of public interest, not just to religious groups, and we've seen at least 2 amicably trying to come in on the very short time periods allowed. It may well be that other religious groups have an interest. It may well be that groups who are not religious have an interest. Though that process hasn't been allowed to take place, we have been afforded a very, very short time to prepare legal argument on complex constitutional issues. And frankly, my lady, it is unseemly for a group of applicants to put the state under the kind of pressure that these applicants did in circumstances where it is dealing with very, very pressing matters of state. Your ladyship will know that all 3, the president and 2 ministers were joined in these proceedings. It requires them to divert their attention away from what they're doing to respond to this. 3 DGs have been tied up in responding to this application. Those are people who are at the moment under very pressing other matters, my lady. So again, we do not suggest that the matter is not urgent. We say only that the timetable has been unreasonable, and on that basis it should be struck.
Well, let's look at it. So we have 1 week of lockdown left, and the court resumes on the 5th. Next week is the last week of lockdown. Monday is the public holiday. And so it's Friday, which leaves 3 days. Are you saying it's not urgent enough to be heard this week, but it is urgent enough to be heard next week in 3 days?
My lady, it is for the applicants to make out the case for urgency. We seek only enough time to deal with the replying affidavit that came in late last night, to update our heads of argument, to deal with it fully,
So
and then the matter can proceed. No, my lady, I don't anticipate at present that we'll file further affidavits. My concern and that of my clients is that they are given enough time properly to prepare, to consider their position. And in that regard, there has been a very substantial shift in the case in the replying affidavits. So that is the concern. I would assume what will happen after this, if the matter is struck, is that we will have to agree a timetable among the parties in order that the matter can come back to court in due course.
Well,
but how the applicants rearrange their affairs if it is struck is in their hands now.
well, when we come back to court, because we must be practical. So if you say it's urgent enough to be heard during lockdown, the question just is when.
My lady, we would consent to the matter being set down next week. I would need to take instructions, but we would also likely consent to it being heard later this week.
And how long do you need to argue?
Assuming matters as they stand, I think we would need. It will depend a little bit on my learned friend's case in Fanta, but I would guess not more than 45 minutes. I should add only, my lady, that my clients don't see costs if the matter is struck.
So you basically want to be struck so that you can have an opportunity to fully prepare on the issues raised in the replying affidavit.
Indeed, my lady. And also, my lady, to send a salutary message to applicants like these that the matter that court proceedings cannot be brought on such short notice that the interests of the state are prejudiced.
My lady, the reply was filed, I think, as my learned friend said, on Monday, but the problem that we faced was that the answering affidavit missed a page, and we've been fighting to get that page, and it only came Sunday night. One of the pages, one entire page. So we didn't know what was said there, and we had a draft ready, and we needed to finalize it. And so and there was a number of emails. I didn't know this was the issue. I could put it up in an affidavit, but at the end of the day, it's not our fault. We could have filed a reply earlier, but they only gave us an extra page on Sunday night. And then
My lady, I'm sorry. The page was sent on Saturday. I was copied on that hand.
Well, that's what my instructions. I'm not copied on emails. My instructions are whatever. If my learned friend wants a little time to consider the reply, without having the matter struck off the roll, because, I mean, then we don't have a problem if the matter stands out to tomorrow for my learner friend to consider that, and we can argue the matter tomorrow. I don't have difficulty with it.
Tell me, Mr. Brown, what do I do with the fact that lockdown ends next week Thursday? I'm going to give our audience a chance as soon as I can.
My lady, the concern that we have is, when the initial lockdown started, nobody ever dreamt that it would come into Ramadan period. Nobody ever dreamt it. But when the second lockdown came, Ramadan starts on Friday night. And we've addressed this in the founding papers quite extensively, my lady, and I don't know if I think the importance of Ramadan is generally known, but in the founding papers, we say, at page 47, paragraph 103, that on 23 April 2020, the holy month of Ramadan will begin. During this time, Muslims fast between sunrise and sunset. Mosque and worship are the cornerstone during this month. Feeding schemes to assist the needy and less fortunate often operate from mosque premises during Ramadan. I'm advised that government intends to roll out mass testing. There was a tender to assist government if they wanted to roll out mass testing. We could use the masjid as a place where that could happen. Now, it was just a few days ago that the WHO even, and this is in reply, published Ramadan guidelines for prayers. It was just about 2 days ago. Now, I can't stress the importance of the period of Ramadan to my clients. It is a month where in the history of this country, in the history of Islam, certainly in our lifetime, a masjid was never locked down in Ramadan. Never ever locked down. And the importance and centrality of a masjid to the month of Ramadan cannot be underestimated. And the state in answer to this concedes all of this and say they're very sensitive to the importance of Ramadan and how important that is to Muslims. But we've indicated in response to the state's attack on urgency that the significance of the month of Ramadan and the significance of prayer in a mosque is far more important, not only because of the additional things that happen, for example, feeding fasting people who may not be able to get a decent meal at the end of the day, feeding the poor, performing the ritual, the normal congregational supererogatory prayers, all of those things, but also the attachment to the Quran, which is set out in the reply. There's a verse of the Quran which says the Quran was revealed in the month of Ramadan, and so the month of Ramadan is a time where the attachment to the Quran becomes an integral part of a Muslim's life, and the Quran is recited much more in the month of Ramadan than it is outside. In the month of Ramadan, the people who know the Quran off by heart read one chapter a night off by heart, and others follow. And that is the Taraweeh prayer. Now, that may not be supererogatory, but it is a fundamental practice and part of the religion to increase the recitation of the Quran during the month of Ramadan. So the attachment to the masjid is something so fundamental to a Muslim's life. And the idea that a masjid is under lockdown and that no prayers can take place in Ramadan.
No, that's not what the government says. The government says that you can pray at home.
Well, no,
They're not prohibiting prayer, or what they are basically doing is what we used to. They are prohibiting congregation.
Yes,
And sorry, I'm interrupting you, and I will give you an opportunity. Just bearing in mind we're going to be talking about urgency now, and I need to admit Mr. Brown to make such submissions too.
Yeah.
My question that I must pose to you is, in your founding papers, your client says they will limit to 20 people to enter the congregation 5 times a day, as I understand it, and then the extra prayer on Friday. In your replying affidavit, if I read it and if I understood it correctly, that number of 20 goes down to 4.
yes.
So now my question is, how many people do you feel is necessary to go to prayer, because remember this is Ramadan, and I do understand, Mr. Bowe, it is an extremely important time, religious time. So I'm not insensitive to that. But you have already curtailed your 24 to reply. What happens if 5 people arrive? Are you going to turn the 5th one away? What happens if 6 people arrive at the same time? Or 8 people? Or 9 people? Remember, on your client's version, everyone has a right, a fundamental right.
That's what needs to be interrogated. What's my client's version? So I think I must take your relation to what my client's version is in the founding affidavit. And why, and upon whom he says congregational prayer is compulsory.
Let's limit ourselves to urgency right now.
Yes. So we're saying that there's a compulsory obligation on the community to keep a mosque open at all times, and that the entire community is sinful for not establishing congregational prayer in a mosque, and that the minimum requirement to lift the sin from the community is 4 people for the Friday prayer and 3 people for all other prayers. And that is the compulsory obligation on the community. And then insofar as his individual obligation is concerned, he says the individual obligation to attend the mosque is on those who can hear the call to prayer without amplification. So that comes from the hadith of the Prophet Muhammad sallallahu alaihi wasallam, peace be upon him, in paragraph 33.2, where he said, that comes from the hadith where the Prophet sallallahu alaihi wasallam dealt with the exemption of a blind man. It's actually 33.1, and a blind man wanted exemption from prayer, and he said, well, do you hear the call to prayer? And the blind man said yes. Then respond by coming to the mosque. So the compulsory supererogatory obligation to attend the mosque and is on those who can hear the call to prayer without amplification.
And how many can hear the call?
So it probably would be a few people. I mean.
How many is a few?
It depends on the area. It depends on the area, but we've made provision for 20 people who would probably listen to the call to prayer, but it could be less. So
Could be more.
no, without amplification, my lady, the Azan takes place. It's like in a building like this.
I don't know that, Mr. Bowe.
My lady, it's in the papers, man.
And that is no. But there may be 21 who arrive. Are you telling me that you are going to turn away 21st person to arrive?
My lady, the state has already curtailed, or for example, funerals. So the state has put a limit of 50 people on funerals. There may be the 51st or 52nd or 53rd person who qualifies under the state's guidelines, but does not make the funeral. The state has also curtailed economic activity of people. So, for example, in the mining industry, the state is now in the latest regulation says they can ramp up 50% of the operation, but the head of the institution must make a determination as to who is an essential worker and who isn't an essential worker. And so the very regime that the state has proposed contemplates that certain people would be cut off in order to achieve the objective of ensuring that not too many people gather because of the imperative of social distancing. So all of those limitations are justified by the state's own regime of limitations. And the question... Sorry, madam.
Who will impose that here?
The state should do it as it did everywhere else. The state banned congregational prayer, and as it regulates who can determine who can come to work and who can go to a funeral, it must make a determination. And what we're saying is that what constitutes reasonable accommodation in this scenario of prayer, where you don't have a situation where the places of worship are completely locked and shut under the current regime. It's a criminal offense to go to the mosque to pray, and people are not entitled even to access the mosque. We've indicated, for example, that the closure of mosques doesn't only prejudice people who pray. There are people who seek refuge at the mosque. There are people who who may have family problems and can come to the imam of the mosque for assistance. Now, if the imam of the mosque is not allowed to go there, like my client is the imam of the mosque, then there may be abused women, for example. We've said this in the papers. And the mosque is close to all of these people. None of them can access the mosque. So I understand the point of limitation, but it's justified from a religious point of view. It's justifiable to limit the congregation to those upon whom the prayer is supererogatory. And from a constitutional perspective, which is really what your ladyship has to decide.
I'm not going into the Constitution.
Yeah.
No.
But
So
that's...
what you're saying is that with Ramadan starting on Friday, and with the measures that your clients intend to put into place at the moment, it will limit, if not entirely obliterate any risk. It will also allow your clients the religious freedoms that they are entitled to in terms of the Quran and the Constitution, and under those circumstances, because specifically Ramadan starts on Friday, it's urgent.
No, it's not only urgent for that. It's urgent also because every single day,
prayers are not being attended.
Prayers are, and the right of religious freedom and freedom of movement and freedom of association is breached every single day, five times a day. And not only that, for people who attend the mosque because they believe it's sunnah, like the amicus curiae, they also not entitled to go to the mosque. And for people who go to seek refuge at the mosque because they want assistance, maybe there's abuse in the home, they can't even access the mosque. So this is a daily prejudice, a continuing prejudice that recurs every single day, 5 times a day at the minimum.
Thank you. If you hear Mr. Khan. On agency?
Maybe can I just say this? First of all, we don't oppose the hearing of the matter as soon as it can be heard. We don't oppose urgency. But while some of my feet, just so that we understand what we deal with, and I'm really limiting myself to the questions of urgency, to identify precisely what the issue is, which we think should be dealt with as soon as possible. You've heard in my learned friend Mr. Bowler's address references to a place of refuge, references to feeding schemes, etc. Let's just understand precisely what the application, because ultimately what's enforceable is any relief of the sort. So there's no prayer relating to the use of the facility for the purposes Mr. Bowler refers to. It's a noble purpose. But can I say this, my lady, in these circumstances presently prevailing, there is absolutely nothing which prevents somebody who wants to give that type of assistance in making application to do so. There is nothing in preventing anybody who wants to set up feeding schemes from from doing so. They have been doing so, lots of people have been doing so since day one of the regulations. So let's not conflate issues in the present case. This application involves a very important issue, and we acknowledge its importance. That importance goes to the balance between religious rights on the one hand and communal rights, which are encapsulated in matters such as access to health and the right to life. And the reason I simply say that is because ultimately what your lady will be called to confront upon first, and this may assist in the question of when you deal with it and the question of urgency, we think it can be dealt with this week, and I say that with due respect to my colleague, Ms. Goodman, is what is the content of the religious obligation the applicants contend for. And I emphasize that because I'm not asking that your ladyship ultimately gets into a debate on different Islamic legal principles. But your ladyship will ask what is the content of their obligation in order to see how that obligation weighs up against other constitutional rights and entitlements and protections of an entire community. So that's the first point your ladyship will ask. The second point your ladyship will ask is, having regard to the content, how does that balance up against other rights, both constitutionally and, I might add, from a religious perspective? But my lady, let's be clear that even though the notice of motion talks about COVID-19 testing stations and feeding schemes, that can be done by proper application with proper permits, independent of going to court. And if you want to do that, you don't need to bring this application to do that or to tie it into anything. It can be done quite independently. The second point is to the extent that people need assistance, and it is true, they do. I've read a number of articles now about a massive problem in relation to domestic abuse. It's a problem across the board in relation to that. Step out and offer that assistance irrespective of the venue that you can use for that. And to the extent that a facility is to be used for that particular purpose, make the proper application because you're allowed to do so. Obtain the permit. So to try to link matters such as testing stations, feeding schemes, access for people who are abused, to the central issue in this case, and I think that issue is important and we do think it should be heard as soon as possible in this week we can. But don't conflate what can be done as a quid pro quo for that particular obligation. Let's deal with the obligation on principle as it should be dealt with, and not as a quid pro quo for other matters that can be attended to in any.
Tell me, how long do you envisage your argument to be?
My lady, I would imagine,
I know it's difficult, but...
Yeah, I would imagine that it's a matter which can be argued in about 3 hours in total. And can I say this, my lady? I sort of whispered to both my colleagues, I didn't get a response. Thursday should give everybody enough time to do their prep. The papers have been prepared. There's the difficulty because of pagination, and that we can sort it out. But I would imagine sometime on Thursday, subject to the court's convenience. And there's another matter I'm mindful of, my lady, and that is the significance and importance of court time. I get the sense that your ladyship has already started reading the papers.
Yes.
You're not to have that process duplicated.
No. Well, I don't intend to do that. I can tell you now.
Yeah. So I would make the suggestion, subject to what my learned friends say, that we deal with it on Thursday.
All right. That's good, man. I think you're the right thing about this. I do think, given your colleagues' stance, and I understand, of course, the applicant is of the view that the matter is urgent, but you have conceded it's urgent enough to be argued during lockdown. I have read these papers, obviously not to the full extent, because I only received probably 85% of them this morning, but I have read them. And I don't think it's correct to burden another judge next week who might have their own problems with the matter that I'm already seized. Would Thursday suit you and Mr. Boda? You can stand on until 10 o'clock on Thursday morning and we can commence argument then.
My lady, we have no issue with Thursday. I would say only that my clients would persist in seeking from your ladyship that the applicants don't move for their interim relief pending that hearing date.
Well, I'm not going to grant any relief. I'll do that right now until such time as I have heard all argument and issue and order.
In that event, my lady, we would support a Thursday hearing.
The status quo will remain as it is right now because obviously I need to hear full argument. It is unfair to anyone for any form of order to be granted.
Indeed, my lady.
Mr. Boda.
Yes, I have not sought any more.
Yes, no, you haven't. Thank you. I will adjourn to 10 o'clock on Thursday morning for everyone. We will commence argument then. If there are any further affidavits to be filed or even heads of arguments, supplementary heads of argument, please could I ask you to email them to my registrar. If it is possible, you can upload them to case lines, but if it is not, please just indicate that in the email to my registrar and I can email them heads of argument and then we will reconvene at 10 o'clock on Thursday.
Maybe before we stand down,
Yes.
can I ask you, just in order to facilitate the hearing, that the applicant be asked to prepare a full index and furnish it to us by tomorrow morning. So we're all on the same page.
Yes.
The second thing, my lady, I inquire because your ladyship gave our heads of argument.
I do have your heads of argument.
If you could hand up our list.
Yes, you can do that. Thank you. I do think, could I inquire whether the 16A notice has been put up in the portals of the court for what it's worth?
We sent it to the registrar.
Did you send it to
Yes.
the registrar? All right. And I saw it is uploaded to case files. And then I think we postponed to Thursday morning. I will reserve today's process for determination on Thursday as well.
My lady, will we convene in person? Will you hear the matter in court?
I'm going to be hearing it in court because we have been directed by the Chief Justice that it affects the Disaster Management Act. It appears to me it is preferable to hear it in open court. Proceedings will be recorded rather than it's almost like it doesn't have persona video conferencing call. It's much better to do it. I apologize. I know it puts all of you a little bit at risk, but we will do what we need to do to keep safe. Thank you.
Let's say something is after the court, my lady.
Mr. Omar, you want
My lady,
be courteous.
no soul shall leave a human body except with the leave of Allah. That's all I need to say. No the Chief Justice, no one. So your lady, they don't have to apologize. There's no risk for me, alhamdulillah. My soul has to leave with the pleasure of Allah, alhamdulillah. So I want to emphasize as an officer of the court, you need not apologize to me at all. Thank you very much.
Thank you. You are all excused. Thank you. Please be safe and be healthy. You are excused.
Thank you.
Mrs. Bobby, thank you for being so patient.
May it please you, my lady.
Could you tell me what's happening in your home?
My lady, unfortunately, the parties could not reach an agreement, except for if your ladyship goes to the draft order. May it please you, my lady.
Yes, I have it. All right.
May it please you, my lady. Paragraph 2 of the order, the parties agreed that paragraph can be deleted. It's not necessary at this stage for the respondent to surrender his certificate of enrollment. The respondent also took issue with paragraph 6 of the order, that is basically directing the respondent to furnish the curator with the firm's accounting records, files, and certain information. That is in dispute, my lady. But paragraph 6 is in dispute.
And paragraph 2?
Paragraph 2, we've resolved. The applicant agreed that it be deleted. So your lady can make a determination on paragraph 6, but the applicant would submit that those orders are consistent with the relief that will be granted pertaining to a suspension. So, paragraph 1, my lady, yes.
Is that in dispute?
No, paragraph 1 is not in dispute. Paragraph 1 is not in dispute. So I will repeat, the paragraphs in dispute are as follows. Paragraph 2, the applicant agrees that that paragraph be deleted. The next paragraph would be the entire paragraph 6. That's in dispute. And what is in dispute is paragraph 8.